of the parties. 5. That the decision creates extopel parallel to the character. 6. The award of the arbitration is final. 7. The award is enforceable through the process of the court. Some of the decided cases of customary arbitration are, this case is Chukwu Dozie Anyabusi and Emmanuel Ogunzi, 1995, 6, Nigerian Weekly Law Report, page 255. It's a Supreme Court case. It's a land matter where they have to establish the customary, the mediation which they took to, and when it got to the Supreme Court, these were the ones that, these are the outlines that guided the decision of the Supreme Court. Also in Irolum Dike and another, and Chief N.O. Nwako, 1997, 3 Nigerian Law Weekly Law Report, Part 495, page 574, is a Court of Appeal decision as well. There are so many cases, but I just try to outline this too, just to show that when the right is done at the customary court, when you get to the appellate court, is judicial precedent, and they have to follow the decision of the Supreme Court. So whatever you decide, if you decide it according to customary court law, and it has all the features that has been outlined here, it is sure that it's enforceable, and that's final. My family court experience members to look not public or private body, institution, court of law, administrative or legislative authority, the best interest of the child shall be primary consideration. It is not only the parties involved, maybe the father or the mother, neighbor in the neighborhood, when they see you maltreat a child, social welfare can be called upon, police officers can be called upon to rescue that child from being maltreated. And when they come to court, there's an incident that we couldn't even bear, because we are not our children's friend. This child was, her body was, how to explain it, the mother used hot iron on her body. So the neighbors called the police, the social welfare, and they brought the child to court. So in the process of trying to interview the child, you have to take the child into chambers. The child could not even walk. So as she was coming into the chambers, I called others, please come and look at. As the child was trying to pull her cloth off, the cloth has clinged to the injury, as if you put gauze on the skin and you want to try to remove the gauze. We couldn't believe that it was the mother that did this to her child, to her daughter. And what did the daughter do? The daughter confided in an auntie who is sister to her mother. She had a stepfather, and the stepfather maybe was sexually abusing her. And she confided in the aunt that this is what is happening to me. And when the aunt told the mother just maltreated that child. just because she said so and so against her husband. These are the things that are happening. Immediately after seeing that child, we have to phone the social welfare in Lasso. She came in, we have to direct her, take this child to the hospital right now for treatment, and we have to order that the girl should be kept in a special correctional center. We call it where they can be kept for care and protection, because she cannot be taken care of in her home. And by the time they finish the medical treatment of this child, one cannot recognize that this is the child that was first brought to court. And after some time, we have to mediate. The mother has to go for counseling sections before we can release the child. In fact, I think the mother of that, the grandmother had to be in court, because we did not want to release that child to go back to where she was first abused, maltreated. So we have to hand over that child to the grandmother to take care of. Then in some instances too, we have paternity disputes, paternity denial, and when they come, we just tell them there is no way we can resolve this matter by not sending it to do forensic laboratory test. And when they do this, when they come back,
presentation, I'm sure we enjoyed the presentation and all the examples and advice that came from it. I will just pick a few things that she said. She says that as customary courts, says though the courts are set up formally by law, but that for the purpose of mediation, decided cases resolution, even in the customary courts, holds, even up to the Supreme Court decisions. The options, different types of arbitration methods, mediation, reconciliation, negotiation, arbitration, a body is set up, not a judicial body, in accordance with customs, traditions. She gave us the conditions under which such arbitration will be withheld. Decisions made. One of the that we, because we use the mediation method, mediation more than any other type of method experience, where there were issues of family, community, to help with some of the issues that come up. It was the interest of the child. She, from my takeaway, she said we are as constituted negotiation, mediation, reconciliation, even where it requires some out of the courtroom, and you hear them in chambers. There's sometimes that there are some constituted stakeholders. There are people that would then be able to mediate or be involved in the matter to resolve the things that took away, and that we should explore as much as possible the alternative disputes resolution methods that. There are any questions? 4 or 5, time permits.
3, 4, 5.
My question is about jurisdiction and ADR. I want to just ask the Lord, if in the course of our education, along the line we find out that the matter we are having is under the Marriage Act, which we cannot adjudicate upon, and we are able to stop the matter along the line and resolve to ADR. Are we still acting within mediation? Because we are told that marriage conducted under the act cannot be annually customary court. While we were handling a proceeding, while the proceeding is going on, we find out that the marriage was conducted under the act, and we have to stop. If we decide to stop the case and proceed on the APR, are we still acting within the law? Or will we only case this answer? I'm sure you get my question.
Apart from matrimonial person, does the customary court have jurisdiction to recover money like to recover money less than 5,000 for the local government, but we don't have any jurisdiction to do that? After there are form of why she goes.
Let your question be clear. Let your question be clear. Make it clearer.
Apart from matrimonial person, customary court, do we have jurisdiction to recover money from the local government if the money is not more than 5,000? As per paragraph 4
of the Judicial Service Commission, also the Commissioner and our lecturer. I pray that God will bless you all in Jesus' name. My question is based on the custody of children. So I want to know the particular age children that they are allowed to go with either the mother or the father from age 1 to 18 or so. Take for example, a woman that has 3 children and she has to go, and the first one is 10, the second one is 8, and maybe the third one is 4 or 5. So do we give the 10? Do we allow the woman to go with the 3 kids? Even when we know where she's going, the children are not going to be comfortable there. And we know the children are going to be much more comfortable with the father. But the woman will decide she wants to go and marry another person. So what do we do? And I just want to know those ages of the children that can be allowed to stay with that.
I'm Kenton Gado from the Columbia. My question is, in a situation where...
Please, can you stop? Excuse me, stop distributing, please. Stop now. You are distracting us, please. Excuse me, the person that is distributing.
Court. And the court feels to have an interim judgment concerning the maintenance allowance of child or children in that marriage. I want to ask if the court had given the interim judgment to pay a certain sum to that father, the situation of the children being with their mother, and this father refuses to pay even while the case is on. What should be the responsibility, or how will the court be able to enforce such? Thank you.
Page 8 of your, you said the last paragraph, page 8. The litigant shall view that the court is a court, and there is Yoruba adage which says, "Akiti court to destroy," meaning we don't come back from court to be friends. And ADR is mediation. And for we in the South, it is very, very rare. If a child father, you are trying to protect the interest of the child, but in the South, it is very, very rare when you see a father being sent to court, and after the court is released, but that stigma will be there. I'm of the opinion that, so far we said it's a mediation. They should continue to mediate on on the father. Not to go to the extent of sending it, because you said it. But if the father of the child should be sent to court and to jail, the stigma will be on the father and on the child. So I think ADR is mediation. We should continue. We should not go to the extent of sending that father to jail.
And from customary court, my first question goes like this. In the case that warrant of arrest is issued, and this particular person brought to the court, and he still insists that he is financial handicap, and whereas he is not, what step will he take? That's number one. Number two, a case of a child is 18 years old, and the father denied of it not to stay with him, and he stayed his mother. Can we see, and as the father can still pay the school fees, everything to this child? That's my question. It does.
Yes, my question is access to the children, access of the children. Right? In the case where the custody of the children is awarded to the father and the mother is a foreigner, through the proceedings of the court, the wife had attempted to take the children away to her country. Right? So what do we do in that matter?
I duly observe all protocols. I want to appreciate the organizer of this retreat. It is quite commendable. I've really enjoyed myself and the opportunity. In the Korodu, there is supposed to be a family court. Then there was no permanent court. Now the courts are in operation. Where do we have the family court for a Korodu division?
My question borders on jurisdiction, which is page 2, the last paragraph, which talks of unlimited jurisdiction in matrimonial causes and other matters, and so on and so forth. The question is, that we are talking of jurisdiction under customary law, but I see a situation where a man meets a lady and they start to live together, and over a period of time they have children, and then along the line there's a problem and they come around. Where do we still have the jurisdiction concerning this type of relationship? Thank you.
While the paper presenter will take some of them as well. So I'll start with Mrs. Downing. Thank you.
Jurisdiction, marriage under the Act, does not empower customary court to litigate on it. Because page 2, second to the last line said, unlimited jurisdiction in matrimonial causes and other matters between persons married under the customary law. So under the Act, when they bring it to you, you will tell them, let them go to file their application in the High Court. Even in family court, I do tell them, we don't litigate on marriage. So that's what I tell them. It's either you go to the High Court. If it's customary court, then you approach the customary. If it's customary marriage, you approach the customary court for the solution. Then the second one, over jurisdiction in local government matters. You know, they have stipulated the amount that you can adjudicate upon. And if you adjudicate upon what is in excess of 5,000 naira, then you know you have jurisdiction. So you have to watch your jurisdiction. Although this can be amended maybe later, because 5,000 these days does not mean anything. I'm quite sure local government will not even have anything, any law that says we find somebody 5,000. So that is it. Maybe the executive secretary will take the matter up to increase that jurisdiction so that you can have work to do. The custody of children ages from 1 to 18. Am I right? Did I hear well that 1 to 18? If the age of that child or presumed to be 18, then it's above what child right for is eligible. That person is an adult. But for the one that is 10-year-old and 10 years, 8 years, and 4 or 5, everybody knows that the mother is always the best person to look after these children. But like I said, the assessors and the social welfare officers will have to look at the source of livelihood. Like I told you, when you say pay 5,000 for a child for a month, some men will say, I don't have money. You see that man that will say, okay, take care of this child. When they go and look at the accommodation, maybe the man is sleeping under the bridge, maybe the accommodation is not suitable for these children to be within. The social welfare will come back and report to us. And it's both of them, both the man and the woman, they will go and investigate, look into the accommodation and let us know. So we have to pick the one which is better, the ones that suit the child better. So if it is the man, who is going to take care of those children? Because when the man wakes up in the morning, he goes to work, what happens to these children in the evening before he comes back? You look at that as well. So it's either way, it is dependent upon what reports the family court gets from these assessors and social welfare officers in order to determine who has these children. But mostly, it is the mother that normally takes care of these children. They don't mind, even where the husband will say, take them to public school. The woman will say, I will try my best, I will send these children to private school and I will pay their school fees. So that is that. I hope it has taken care of it. Then ongoing matter in court. Interim. Okay, maintenance allowance. You know, when the matter is in court, we don't know when it's going to come to an end. Like Justice Idowu said, that we have to look at what is in the best interest of that child. Pending the outcome of the decision of court, the children will be maintained. So the judge or the magistrate will take first the maintenance allowance so that the children will not suffer before the conclusion of that matter in court. The person refuses to meet to pay the amount that the court has ordered him. Like I said, we ask them every day, don't you eat as a man, not considering your children now. You eat, you put on clothes. So your children should be the first thing for you to cater for. And if you refuse, like I said, you have to enforce it. You can't just come to us and say, I don't have money. It is when we say, okay, go to Kirikiri. You see, they try and make contacts with members of their extended family to raise money to give this woman to take care of the children. And it has been yielding good results. That is what we do. It's not that we like it, but all of them cannot be coming and say, we are not going to be responsible for our children. Why did you bring them into this world in the first instance? a child is too much, because aggregately at the end of the month, every one of us, we know how much we expend on ourselves. So we have to put our children first before us. When they are going to school in the morning, if it's 100 you have to give for the child, for transport and for ice cream or something like that, you know how these children will feel when they are at school. Some of their mates that their parents that paid for their meals will be eating, then your child will be looking at them. That's not good enough. Stigmatize. You are not sending them to jail. You just want them to go and have a rethink. What I'm doing is it good for this child by depriving this child of necessities. That's what you look at. We talk to them, like the ADR, we mediate, we advise them, we counsel them that this is your future. If you are not taking care of your future, then you don't have peace at old age. There are some old men, they are crying, but you can't see the tears, or the tears inside their hearts, because they were not there for their children when they were supposed to be there. And when the children too has reached heights of what they want to become in life, you can't come around and say, this is my child. They will rebuke you and say, you are not my father. It has been happening. But I pray it's not going to happen to us. Yes, if we take care of them, when it's time for you to go on holidays, one is in France, one is in UK, one is America, they will be competing to buy tickets for you. Mommy, come to France. Daddy, come to UK, and you'll be happy. But how much are we asked to take care of them? But you are denying them. So it's not stigmatization. Like I tell you, I have a friend. Right now, one parent, they are high position for their children in United Nations. So, can 5,000 a month take your child to that position in future? Because they are going to the best school. Internationally, globally, they are going to the best school. And it's the best that they will take when they interview them for that international position. Yes. Am I right? 18 years old, like I will tell people, although the law says 18 years old, but if we look at our educational system, by the time somebody is 18 years, maybe undergraduate, maybe in colleges of education, then polytechnics, or colleges of technology. So if they cannot earn a living, you have to still provide for them to see them through education. We cannot say stricto sensu, the law says 18 years. So we have to look at that as well. To a foreigner wife, and the wife wants to take the child out of the country. You can approach the family court, and the family court will grant you injunction, provided you know the address where the person will be served as soon as possible, so that this child is not taken out of the country. You can approach the family court. Even we have family court at the high court level, you can approach that one too. Having issues where they are not married. Am I right? Where they are not married. After some years, when you are cohabiting with yourselves, it will be regarded that you are married. It's only that there are some rights when you are married that you are entitled to, you will not be entitled to in this case. if you are married under the act, you are entitled to some rights, obligations, but where you are just cohabiting, at the end of the day, it is what individual put in that you put out, but they will still be regarded as marriage, but not under marriage act.
So their marriage, because as far as I'm concerned, they're not married. But concerning those children, I think the Child's Right Act will apply for those children. When we give orders in court about maintenance of children and such orders, we expect that those orders must be carried out. I am aware that in the customary court now there is nothing in place as such to ensure that the man or the woman who is maintaining should continue to do so. We are looking at issues where we can approach the social welfare office, because in the family court there are assessors and there are social welfare officers, probation officers. When the court orders that maintenance must be done, these probation officers follow it up and ensure that that order is carried out. If the man is a civil servant, they go to report in their office so that a certain amount will be deducted from the man's salary every month and make sure it is enforced. So we at the commission are looking at how we can approach the officers that we might assign to a group of courts, and they will be going around so that when such orders are made, they can be enforceable. That is in the interim, pending the final decision of that court. Thank you, our speaker, Mrs. E.B. Down. For my little takeaway, it says whatever you don't have jurisdiction on, you can't mediate on. That's my takeaway from me. Then the other thing is, like we were told by Justice Dowdu, enforcement, we should allow people that have been given the job of enforcement to do the enforcement. We'll do our own part of it and let them do their own part of it. I think that's the way. As the chairman, I just want to put in here, we talked about ADR within the colonialized. Now, the question will be, what has happened to the structure? What have we been able to record? What have we been able to share? What are the good things that we have found in it that have been put in place so that we can even sell what we're doing well? I think those are some of the things that we need to look at with the customary courts and take away and work on those things that have not been working so well. So that even us, at some point in time, we might then find something as to the system that we have run, that has been brought back to us now by the colonial man, those that colonized us, and have been called it ADR. So that's just my own contribution as the chairman of the session. Thank you very much for your attention. Thank our commissioner, Mrs. Abisola Oshodi, for taking the time off to spend the day with us. We thank her for her support of the commission always. I also want to take this opportunity to thank Mrs. Dowdu. She doesn't sit in the family court anymore, Pioneer Family Court Magistrate. So now, thank you so much for coming and sharing your knowledge with us. We will excuse our facilitator and our chairman, and then we'll take 5 minutes again, then we'll come back to our own business of the day, where we interact with ourselves. Thank you very much. To how we are going to improve on this program. You know, we had one earlier in the year, that one was supposed to be for last year, and this is the one for this year. And I'm glad to say that I thank you all for a very impressive turnout. So, our interactive session with you will take just about 30 minutes. So,
I greet the Secretary of the GSC and other members of the IT. First of all, I want to appreciate you for this seminar. It's quite GP Omoyeni Murile Agegi. GP Omoyeni GP. Yes, ma'am. Murile Agegi Customary Court. I want to appreciate you for this seminar. It's quite educative.
Excuse me, please keep quiet so that we can hear ourselves.
I want to ask about the way I've asked the commissioner before the event, but unfortunately we didn't have the opportunity. The last seminar we held, when the honorable commissioner came here, he gave us his words that made the division of the customary court to be extended to criminal cases. I think that is environmental sanitation matters will be handled by, say, July. That will commence that what is going on it. And as at that time, we were looking out to the extension of that division. And today, we were expecting him to talk about it, but we didn't hear anything about it. I don't know whether the Honorable Secretary will be able to let us know about that. Thank you.
This meeting, and I know that the Honorable Attorney General said that we should be expecting an increase, a new law. I am aware that it is in progress, and we're just waiting for it to be submitted to the governor for approval before we send it to the House as a bill to be made into law. So we will still be patient.
President of Murile Customary Court. Man, we have been enjoying ourselves since morning, but it's a pity our colleagues from the Ikorodu, out of their case, I want to know about their case, man.
But you are taking out the case for Ikorodu. Yes, thank you very much. We are working on it. In fact, we still discuss with the Attorney General this morning. We have written to the Attorney General, we have written to the Chief Judge. I think that's about all what we can do for all of us to now work together and impress upon the Ikorodu local government and its environs, because I know that the other local governments in the Ikorodu area also are owing. Although we know that they are not owing as much as, excuse me, I know that they are not owing as much as what Ikorodu is owing, but it always starts from somewhere, 1 month, 2 months, 3 months. So please, we are working on it, and we hope that before the end of this year, it will not last a year, that we'll be able to sort the matter out. Thank you very much.
Some of the questions I wanted to ask, that is on Ikorodu, because it's a bit painful for others too. That's why the president of that company brought that incident out. I just want to ask, man, is it possible, I don't know, is it possible for salary for judicial customary courts to be removed from the council? Is it possible? If it is possible, I think it will cover well for every one of us. That's the question.
Of anything that can be possible to assist ourselves. So these are issues that we are looking into. If it's possible, then it will happen. If it's not possible, there will always be a plan B. So you've been patient enough. I still enjoin you to continue to be patient. We are working, because I personally am not happy about it. And even I'm always embarrassed when I see the people from Ikorodu. So we are working on it. Thank you very much. And I have 1 or 2 issues to discuss. One of the issues I want to discuss is that it is quite painful that we may, when we move you from one court, and please listen carefully, when we move somebody from one court, let's say from court A to court B, and the person moves, even if it's in the middle of the month, please be assured that your salary will be paid for the end of the month in court B. I will ask you not to go back to court A and collect salary and collect from court B. It is not right. It is fraudulent. So I would, because I don't want people to tell me that we don't know. It is not something we should tell you about. It is something that you should know. That if you are deployed from court A, maybe on the 3rd or 10th day of the month, and you go to court B, it behoves upon you to receive your salary in court B. Not to now say that because you are not very busy in court B, you went back to court A. So please let us note that. If we get any more reports from that, it will be a more serious matter. So please please take note, and especially the presidents of courts should also take note. Secondly, I must say that we haven't received petitions against members, and it has reduced considerably. So I would enjoy you to continue in the way you are. Some of the petitions we have received recently do not really hold water. So it isn't against your person, it isn't against your procedure. It's just probably against the lawyer who is angry, or somebody who is angry that his case went some other way. It is to be expected. So I would enjoin you to continue to do better than you're doing now, and that the issue of integrity should be paramount in our hearts, because that is the most important thing in this our job of adjudication. I guess that is all we have to say. I want to thank you all for taking the time to come here to listen to the various resource persons we have provided, and I believe that when you go back to your courts, you will take with you what you have learned and apply. And please, at no time, if you don't understand, please don't hesitate to come and see us at the commission. I was a magistrate, and I sat as a family court magistrate for so many years. So a lot of things I know, I can read. We can sit down and look at it and think to ourselves, okay, this is what you should do, this is what you should do. Don't hesitate to do that. Asking questions will not make you less of a person. It will make you a better person. I thank you all very much. I think we have been able to, we asked some group of people to put together, when we are through here, we ask you to wait a bit. You even have to wait, because we have made provisions. We have made provisions